Alright, Part 382, Controlled Substance Alcohol Abuse, Federal Motor Carrier Safety Administration. Alright, Subpart E, Consequences for Drivers Engaging in Substance Use Related Conduct. 382.501, Removal of the Safety Sensitive Function. Except provided in Subpart F, this part, no driver shall perform safety sensitive functions, including driver of a commercial motor vehicle, if the driver has engaged in conduct prohibited by Subpart B of the Department of the Alcohol Control Substance Rule of another agency. No employer shall permit the driver to perform safety functions, including the driver of a commercial motor vehicle, if the employer has determined that the driver has violated section. Purpose of the Department of Commercial Motor Vehicle meaning the commercial motor vehicle in commerce defined in 382.107. The commercial motor vehicle is interstate commerce defined in Part 390 of the Subchapter 382.503. Required evaluation and testing. No driver shall engage with the conduct prohibited in Subpart B of the part shall perform safety sensitive functions involving the driving of the commercial motor vehicle unless if the driver has met the requirements of Part 40, Subpart O of the title. No employer shall permit the driver has engaged with the conduct prohibited by Subpart B with it part of the perform safety sensitive functions, including driver of commercial motor vehicle unless if the driver has met requirements of Part 40, Subpart O of the title. 382.505, other alcohol-related conduct. No driver tested under the provisions of Subpart C of the department who have found to have an alcohol correction of 0.02 or greater than less than 0.04 shall continue to perform sensitive safety functions of the employer, including the driver of the commercial motor vehicle. Nor shall the employer permit the driver to continue to perform safety-sensitive functions until the start of the driver's next regular scheduled duties per period not less than 24 hours following the administrative test. Exempt provided with the paragraph of the A of this section, no employer shall take any of the action over this part against the driver based solely on the test result of the showing alcohol concentration less than 0.04. This does not permit an employer to with the authority independent to part of the part that taking the action otherwise consistent with the law. 382.507 penalties. An employer driver who violates the requirements of the part shall be subject to the civil or criminal penalties. Title 49.521B. With an addition, employer with the driver who violates the requirements of Title 49 CFR Part 40 shall subject to the civil or criminal penalty provision. Title 49, Part U.S. United States Code 521B. Subpart F, Alcohol Misuse Control Substance Use Information Training Reference. 382.601, Employer Obligation Promulgated with the Policy on the Misuse of Alcohol Use of Controlled Substances. General Requirements. Each employer shall provide educational material explaining the requirements of this part. Employer's policy procedure respect with the meeting of the requirements. Employer shall ensure the copy of the materials distributed to each of the driver prior to the starting of the alcohol controlled substance testing used in this part to each of the drivers subsequently hired transferred into the position requiring driver commercial motor vehicle. Each employer shall provide a written notice to the representative of the employer organization availability information. Related content. The material is made available. The driver shall include the detailed discussion at least the following: identify the person designated by the employer to do an answer for the driver's question about the material. The category of driver who is subject to the provision of this part. Sufficient information about the sensitive function performed. Those drivers that meet the clearly performed period of the workday of the driver that is required to compliance with this part. Specific information concerning the driver conduct prohibited by this part. The circumstances under which the driver is tested for alcohol and/or controlled substance under this part, including post-accident testing under 382.303D. Procedure that you will be used to test the presence of alcohol controlled substance, protect the driver, the integrity of the testing, possess the safeguard validity of the test result, ensure those results are attributed to the correct driver, including post-accident information provided, procedure instruction required for 382.303. Requirement of the driver to submit the alcohol controlled substance to testing and administer with accordance with this part. Explanation of the constitute the refusal to submit the alcohol controlled substance testing attendant consequences. The consequence for the driver of the found with violated Subpart B is include the requirement for the driver to remove immediately from the safety sensitive functions of the procedure Part 40 of Subpart 0 of this title. Consequently, the driver is found with alcohol concentration of 0.02 greater but less than 0.04. Information concerning the effect of the alcohol controlled substance for the individual's health, work, personal life, the time, the symptoms of the alcohol controlled substance problem, and available the method of intervening with the alcohol controlled substance problem. It is suspected that including concentration referral of the into employee assistance program and referral management. The requirement of the following personnel information collected and maintained under this part shall be reported with the clearinghouse verified positive alterated substance drug test result alcohol confirmation with the test of concentration 0.04 or greater, higher. Refusal to submit any of the tests required within Subpart C of this part. Employer report of the actual knowledge defined in 382.107. On-duty alcohol use pursuant to 382.205. Pre-duty alcohol pursuant to 382.207. Alcohol use of the following accidents pursuant to 382.209. Controlled substance pursuant to 382.213. Substance abuse professional SAP defined in 430. 43 with the title of the report, successful completion of the return to duty of the process. A negative return duty test, an employer reports the completion of the following up test. Optional provision, the material supplied with the driver that must include the information additional employer policy with respect to the use of alcohol control substance, including any of the consequences of the driver found to have specified alcohol control substance to level that are based on the employer's authority, independent part. Such additional policy for the consequences must be clearly obviously described as based on the independent authority. Certificate of receipt. Each employer shall ensure that each of the driver the required the sign of the statement of the certifying he or she received the copy of these materials described in section. Each employer shall maintain the original signed certificate. May be provided with a copy of the certificate of the driver. 382-603 training of the supervisor. Each employer shall ensure that all the personnel designated supervisor driver that has received at least 60 minutes of the training alcohol misuse that received at least additional 60 minutes of training control substance use. The training will be used the supervisor to determine whether reasonable suspicion to require drivers to undergo the testing of 382-307. The training shall include the physical behavior, speech, performance indicators of probable alcohol misuse and use of control substance. Recurrent training for supervisor personnel is not required. 382-605 referral evaluation treatment. The requirement for the referral evaluation treatment must be performed in accordance with the Title 49, Part 40, Subpart O, Subpart G. Requirements, procedure, implementation, commercial driver's license, drug, alcohol clearinghouse. 382-701 drug, alcohol clearinghouse. Pre-employment inquiry required that the employers must not employ the driver subject with the controlled substance or alcohol testing under this part of the performance safety sensitive the function without first conducting pre-employment inquiry clearinghouse obtaining the information whether the driver the verified positive unadulterated substance controlled substance. Substituted controlled substance has been alcohol confirmation testing of the 0.04 or higher of the refusal submit the test violation 38.2.11 that employers reported actual knowledge of defined 382.107 the driver the alcohol duty violation 382.205 alcohol before duty violation 382.207 the alcohol following the accident violation 382.209 using controlled substance violation 382.213. The employer must conduct a full query under the section which of the releases the information in the clearinghouse to the employer required that the individual driver to give the specific consent. Annual query required. The employer must conduct the query with the clearinghouse at least once per year with the information all employees subject to the controlled substance and alcohol testing under this part determine whether the information exists in the clearinghouse about the employees in lieu of the full query described in paragraph A2 of the section. Employer must be obtained the individual driver's consent to conduct a limited query safety annual query requirement. Paragraph B1 of this section. Limited query will tell employer whether the information about the individual driver in the clearinghouse but will not release the information to the employer. The individual driver may give the consent to conduct limited queries with effectiveness more than 1 year. If limited queries show that the information exists in the clearinghouse by the individual driver, the employer must conduct the full query in accordance with paragraph A2 of the section 24 hours of the conducting limited query. If the employer fails to conduct a full query within 24 hours, the employer must not allow the driver to continue performing safety-sensitive functions until the employer conducts the full query and the result of the conforming the driver's clearinghouse containing no prohibitions as defined in paragraph D of the section. Employer notification if information described in paragraph A of the section entered within clearinghouse about the driver during the 30-day period immediately following an employer conducting query of the driver's records. Federal Motor Carrier Safety Administration will notify the employer. Prohibition. No employer may allow the driver to perform any safety function with the result of the clearinghouse is required to demonstrate for the driver the verified positive adulterated substitute the controlled substance test result of the alcohol confirmation test with the concentration 0.04 or higher. Refuses to submit the test for violation 38.211 if the employer has reported actual knowledge of 382.107. The driver uses alcohol duty with the violation 382.205. Uses alcohol before the duty of the violation 382.207. Alcohol following accident in violation 382.209. Use the controlled substance violation 382.213 except for the required of the clearinghouse. Demonstration. The driver has successfully completed SAP evaluation referral of the educational treatment process set forth to Part 40, Subpart O, with the title of the achieved the negative return duty. The test result of completing following up testing plan prescribed in the SAP. That if the driver has not completed all the follow-up tests prescribed in the SAP in accordance with the Title 307, the title will specify the SAP report required in Title 43.11 of this title. of the driver has completed with the SAP evaluation, referral to the educational treatment of the process set forth in Part 40, Subpart O of the title of the achieve the negative return of the day to the test result of the employer, assume that the responsible for the managing following of the test process associated with the testing violation. Record keeping required. Employers must retain 3 years of records of each query. All information received, the response to each query made under this section and January 6, 2023. Employers must maintain a valid register fulfills this requirement. Alright, 382.703, driver consistent with a permit access to information clearinghouse. No employer may query a clearinghouse to determine whether the record exists for the particular driver without first obtaining the driver's written electronic consent or electronic consent. Employer conduct the search must be retain the consent for 3 years after the date of the last query. Before the employer makes access to information contained with the driver's clearinghouse record, the driver must submit the electronic consent through the electronic clearinghouse, granting the employer access to the following specific records: verified positive adulterant substance controlled substance test and alcohol confirmation test, concentration 0.04 or higher. Refusal to submit the test in violation 38.2.11. Employer's report actual knowledge defined in 38.2.107. On-duty alcohol use pursuant to 382.205. Pre-duty alcohol use pursuant to 382.207. Alcohol following accident pursuant to 382.209. Controlled substance use pursuant to 382.213. SAP reports successful completion return to duty process. A negative return to duty process. Employer reports the completion of the following up tests. No employer may permit the driver to perform safety-sensitive function if the driver refuses to grant the consent required in paragraph A and B of the section. Driver granting consent under the section may provide the consent of the electronically agency through the clearinghouse prior to releasing the information to the employer in accordance with 382.701 A2 or B3. Driver granting consent under the section grants consent for the agency to release information to an employer in accordance with 382.701. Alright, 382.705, the reporting of the clearinghouse. The MROs within 2 business days make the determination verification. MRAs must report the following information about the driver to the clearinghouse: verified positive altered substituted controlled substance test, refusal to test to test determination MRO in accordance with the Title 49 CFR 4191A5, 7, 11B, and D2. MRO must provide the following information: each of the controlled substance test results specified in paragraph A1 of the section. Reason for the test: federal drug testing, custody, the control form of the specimen ID number, the driver's name of the date of the birth, the CDL number, the date of the issuance, employer's name and address, the U.S. dot number, if applicable, the date of the test, dairy, verified result of the test, result of the test, results, one of the following, positive including controlled substance identified, refusal to test adulterated, refusal to test substituted, refusal to provide sufficient specimen of the MRO makes a determination in accordance with the statute 4193. If the employer does not have the medical condition that has high degree probability that could preclude the employer to provide sufficient amount of the urine. Under this part of the refusal would also include refusal to undergo a medical examination evaluation of the substitute of the qualifying medical condition 1 business day, making the change with the result of the reporting in accordance with the A1 of the section. The MRO must report the change result of the clearinghouse. Employers must report the following information about the driver of the clearinghouse by the close of the 3rd business day following the day of the obtainment of the information. The alcohol confirmation total test result of the alcohol concentration of the 0.04 greater than negative return to duty date. Negative return to duty test result of the refusal to take an alcohol test pursuant to Title 49 CFR Part 40-61. Refusal to test determination made in accordance with Title 49 CFR 4191A through 4A6, A8, 11, D1 or D1. But in the case of refusal to test at A11, the employer may report only those administration made by the specimen collector. Report of the driver successfully completed all the follow-up tests and described in the SAP report according to the statute 40, 307, 309, and 311 of the title. For information required for the report reported under this paragraph B1 of the section must include the applicable reason for the test, driver, the name of the day of the birth, CDL, name of the state of issuance, employer's name and address for the U.S. dot number, the day of the test, the day of the test result was reported, the test result of the test result by one of the following: negative 1 required return due to duty test amended in accordance with 382.309, positive refusal to take test for each report of the violation Title 49 CFR 4261A, Title 4191A1. Employer must report the following information: documentation including but not limited to electronic mail, other contemporaneous records of the date and time of the day of the driver to notify of the repair of the testing result and the time of the data testing site with the location where the employee was directed to appear with the affidavit providing evidence of such notification, documentation including but not limited to electronic mail, electronic mail the corresponding to the affidavit indicating that the date of the employee was terminated or resigned. The documentation including but unlimited electronic mail, otherwise corresponding affidavit showing that the consortment of the third party administered reporting violation with the designated the service agent of the employer himself with his or herself as the driver, pursuant to the paragraph B6 of this section, when the reported refusal occurred, if applicable, documentation included with the certificate, the service, and other evidence showing that the employer provided with the employer with a documentation report on paragraph B3 of this section. 4. Employers must report the following violation included with the third business day of the following the day of the employer obtains the actual knowledge of the defined in 382.107 on-duty alcohol pursuant to 382.205, pre-duty alcohol use pursuant to 382.207, alcohol use following accident pursuant to 382.209, controlled substance pursuant to 382.213. For each violation, paragraph B4 of the section, employer must report the following information: driver, the name of the day of birth, CDL number, the state of the issuance, employer name and address of the U.S. number, if applicable, date of the employer obtained with the actual knowledge of the violation, witness of the violation, any of them included with the contact information, description of violation. 6. The evidence supporting each fact alleged with the description violation required by the paragraph B with the section must be included, not limited to affidavit, the photograph, videos, audio recordings, employee statement other than admission pursuant to 382.121 corresponds to other documents, and a certifying service of the evidence showing the employer provided the employee with the information reported in the paragraph B4. Employer who employed with him or herself, the driver must designate the consortment of the third party administrator to comply with the employer requirements paragraph B of the section related to his or her own alcohol control substance use. All right. Consortment of third party administrator the employer with the designated of the consortment of the third party administrator to perform the employer requirement of the paragraph B with the section, regardless of whether there is a consortment of the third party administrator to perform the requirement the employer retains ultimate responsibility for the compliance with the section. Explanation: exemption: employer does not retain the responsibility for the consortment third party administrator designated to complete with the employer's requirement as described in paragraph B6 of this section. The SAPs or the SAP must report with the clearinghouse each of the driver that was complete with the return duty of process in accordance with Title 49 CFR Part 40. Subtitle over the following information: SAP name and address, telephone number, the driver, the name of the day of the birth, CDL number, the name of and the state of the issuance, date of the initial substance abuse professional assessment, date of the substance abuse professional determined the driver that demonstrated the successful compliance defined in Title 49 CFR Part 40 Subpart O was eligible for return to duty testing under this part. The substance abuse professional must report the information required in paragraph D1 through 3 with the section close of the business day following the day of the initial substance abuse assessment. Must report the information required in D1-4 with the section close of the business day following the determination of the driver that has completed the return to duty process. Reporting truthfully and accurately each person at either the action of the must report truthfully and accurately clearinghouse expressly with the prohibited reporting information he or she knows and should know in the false and accurate. 382.707, the notice of driver entry of the revisions and removal of the release of the information. Federal Motor Carrier Safety Administration must notify the driver the information concerning the driver that has been added to, revised, removed from the clearinghouse. Federal Motor Carrier Safety Administration must notify the driver informing concerning the driver has been released for the clearinghouse to employer specifying the reason for the release. Driver that will be notified lettering of the U.S. mail with the draft of the record with the state driver's license agency issued with the driver's commercial driver license exemption. A, the must provide with the clearinghouse alternative means the address notification electronic mail. 382.709, driver's access to the information in the clearinghouse. Drivers may review information clearinghouse about himself or herself except for the otherwise restricted law regulation. Driver must register with the clearinghouse before accessing his or her information. 382.711, clearinghouse registration. Clearinghouse registration requires each employer to serve the agent with a register for the clearinghouse before the accessing reporting information. Clearinghouse employers with clearinghouse registration must include name, address, telephone number, U.S. number. Except for the registration does not have the U.S. number, it may be requested to provide other information verifying identity. Name of the person employer authorized to report the information obtained with the information clearinghouse. Additional information from the Federal Motor Carrier Administration validate with his or her identity. Employers must verify the name of the person authorized. Paragraph of this section annually identification of the consortment third-party administrator, the other service agent that is comply with the requirements of this part. Applicable the authorization consortment and third-party administrator required for the report of the information clearinghouse. The employers must update with any change of the information within 10 days. The MRO, substance abuse professional, medical review officer, substance abuse professional must provide the following to apply with the clearinghouse: registration, name and address, telephone number, and additional information. For Federal Motor Carrier Safety Administration needs to validate application identity, certification of the applicant to access the clearinghouse condition that his or her compliance, applicable qualification and or training requirements of Title 49 CFR Part 40. Evidence required professional credits verified by the application currently meets the applicable qualification training requirements of Title 49 CFR Part 40. Consortium and third-party administrator for the other service agents. Consortium and third-party administrator for the other service agents provide following they apply with the clearinghouse registration, name, address, telephone number, and additional information. Federal Motor Carrier Safety Administration needs to validate application's identity, name, title, and telephone number to the person authorized to report information obtaining information from the clearinghouse. Each consortium and third-party administrator for the other service must verify the name of the person authorized under the paragraph D2 of the section annually. Other 382-713 duration, cancel, revocation, accept the clearinghouse registration valid for 5 years unless canceled with a revoked cancellation. Federal Motor Carrier Administration will cancel clearinghouse registration for anyone who is not required to report it for the clearinghouse for 2 years. Revocation for Federal Motor Carrier Safety Administration have the right to revoke clearinghouse registration anyone that fails to comply with the prescribed rights. Restriction to access unaccessed clearinghouse include but not limited to submission inaccurate, false information, misuse of the misappropriation. Access rights, protected information clearinghouse, failure to maintain and request qualification, certification, training requirements set forth in Part 40 of this title. 382-715 authorization information into the clearinghouse. Consortium and third-party administrator. No consortium and third-party administrator or other service may enter information into the clearinghouse on an employee's behalf unless the employer designates the consortium and third-party administrator or other service agent. Substance abuse professional. Driver must designate the substance abuse professional before the substance abuse professional can enter any information about the driver's return to duty to process in clearinghouse. Alright, 382.717, proceed with the correcting information in the database. Petition limited to the accurately reported information under this section. Petitioners may challenge only the accuracy of information reported, not the accuracy of the test result refusal. Exemption petitioners may request the Federal Motor Carrier Safety Administration remove the clearinghouse any employee report with the actual knowledge of the driver to receive the traffic citation for driving a commercial motor vehicle while under the influence of alcohol, controlled substance. For the citation do not result in the conviction for the purposes of this section. Conviction that has the same meaning as used in Title 49 CFR Part 383. The petitioner requests the Federal Motor Carrier Safety Administration remove the clearinghouse of employee reports of the actual knowledge other than the provided with the paragraph 821 of the section. Report does not comply with the reporting requirements 382.705B5. Petitioner may request the Federal Motor Carrier Safety Administration remove the clearinghouse employee reports violation under Title 49 CFR 4261A1. And 4191A1, the report does not comply with the reporting requirements of 382.705B3. Petition any driver, the authorized representative of the driver, and with a substitute made a petition with the Federal Motor Carrier Administration contesting the accuracy information clearance. House for the petition must include the petitioner's name and address, the telephone number, the CDL number, the date of issue, and the detailed description of the basis of the allegation of the information not accurate, evidence supporting the allegation of the information not accurate. Failure to submit the evidence is cause of dismissing the petition. Submission of the petition may submit the his or her petition electronically through the clearinghouse writing the Federal Motor Carrier Safety Administration Office of Enforcement Clients Attention Drug Alcohol Program Manager, 1200 New Jersey, South New Jersey, Avenue, Southeast Washington, D.C. Notice the decision within 45 days receive the completing of the petition. Federal Motor Carrier Administration inform the driver with the writing of the decision to remove the retained corrective information and the database provided the basis of the decision. Request to expedite treatment. The driver may request to expedite treatment to correct with the inaccurate information his or her clearinghouse regarded information recorded under paragraph A1 of the section. Inaccuracy currently preventing him or her from performing safe-sensitive functions to remove the employer reports under paragraph A2 of the section. Such reports are currently preventing him or her from performing safety-sensitive functions. The request must include the original petition and a separate documentation. And the Federal Motor Carrier Safety Administration grants expedited treatment and subsequent information and subsequently inform the driver of the decision within the 14 days of the receipt of the complete petition. Alright, administrative review. The driver may request the Federal Motor Carrier Safety Administration conduct administrative review here if he or she believes the decision made in accordance with the paragraph D and E of this section was an error. Request must be prominently stated at the top of the document. Administrative review of the drug alcohol clearinghouse decision. The driver may submit his or her request electronically through the clearinghouse or in writing the Associated Administrative Enforcement, Federal Motor Carrier Safety Administration, 1200 New Jersey, Avenue, Southeast Washington, D.C. Driver request must explain the error he or she believes the Federal Motor Carrier Safety Administration provided information of the document support his or her argument. The Federal Motor Carrier Safety Administrative review no later than 30 days after the receiving the driver's request to review the Associated Administrative decision will constitute the final agency action. Subsequent notification employer will one information correct with the removal in accordance with the section the accordance with the Title 49 CFR Part 10 Federal Motor Carrier Safety Administration will notify the employer access for the incorrect information the correction removal was made. Alright, 382.719, availability, removal of the information. Driver information is not available. If the information about the driver with the drug, alcohol violation will not be available to an employer conducting a query with the clearinghouse after the following conditions relating to the violation are satisfied. Substance use professional reports to the clearinghouse have the information required in 382.705. The employer reports to the clearinghouse that the driver returned to duty status results are negative. The driver current employer reports that the driver has successfully completed all the follow-up testing prescribed in the substance abuse professional report in accordance with the statute 4307, 311. This title, 5 years have passed since the day of the violation determination. Driver information remains available. The information about the particular driver's drug alcohol violation will remain available if the employer is conducting query with all the requirements. Paragraph A of this section has been met. Exemptions within 22 business days of the granting of the request to remove the pursuant 382.717A21 Federal Motor Carrier Safety Administration will remove the information clearinghouse. Information about the particular driver's drug alcohol violation be removed in accordance with 382.717A23 in accordance with the Title 49 CFR Part 10. Driver information remains available. Nothing in this part shall prevent Federal Motor Carrier Administration from using information removed under this section of research, auditing, and enforcement purposes. Alright, 382.721 fees. The Federal Motor Carrier Safety Administration collects reasonable fees for injuries required with the query with the clearinghouse, so that no driver may be required to pay with the fees active with his or her information clearinghouse. Alright, 382.723 unauthorized access use of the prohibited access. Expressly authorized in so part, no person at any of the access for the clearinghouse, no person at any of the share with the distributed publish otherwise relief the information clearinghouse, except for the specifically authorized law that no person may require report inaccurate and misleading information from the clearinghouse. Employer use the information received from the clearinghouse limited to determining whether the prohibition applied with the driving performing the sensitive safety sensitive function with respect to commercial motor vehicle. No employer may divulge and permit any other person entity of the divulge information for the clearinghouse to any person entity that not directly involved with determining whether the prohibition applied with the driver being performing a safety sensitive function with respect to commercial motor vehicle violation section subject to civil criminal penalties according with the applicable law, including those set forth in 382.507. Nothing in this part shall prohibit the Federal Motor Carrier Safety Administration from accessing information on individual driver of the clearinghouse and research, auditing, and enforcement purposes. Alright, 382.725, acts of the state licensing authority. In order to determine whether the driver is qualified to operate with a commercial motor vehicle, the chief of the commercial driver license official of the state must obtain from the driver the record with the clearinghouse if the driver has applied with the commercial driver license from the state by applying with the commercial driver license. The driver deemed to consent with the release information from the clearinghouse in accordance with the section. The chief commercial driver license official visual use the information received with the clearinghouse is limited to determining the individual qualification to operate with a commercial motor vehicle. No chief driver license official may divulge or permit any other person entry any divulging information from the clearinghouse to any person entity directly involved with determining an individual's qualification operating the commercial motor vehicle. A chief commercial driver license official who does not take an appropriate safeguards to protect the privacy and confidentiality of the information obtained under this section is subject to the revocation of his or her right access under the section 382.2727. The penalties employee the MR medical review officer or service agent who violates a provision of this part shall be subject to the civil or criminal penalty provision in Title 49 U.S. Standard Code 521 B2C. And that was the reading of Part 382, Controlled Substance Alcohol Use Testing.